5 seconds to go. Start. We are in complete agreement with the findings regarding the incriminating circumstances as recorded by the High Court. On the basis of the aforementioned circumstances, the High Court came to the conclusion that the appellant was responsible for the incident of shooting inside Lal Killa on the night of 22nd December 2000, which resulted in the death of three soldiers of army. It has also been held by the High Court that this was a result of well-planned conspiracy between the appellant and some other militants, including deceased Abu Shamal alias Fazal, who was killed in an encounter with the police at house number G73 Batla House. The High Court has also deduced that it was at the instance of the appellant that the police could reach that spot. The High Court has further come to the conclusion that it was in a systematic manner that the appellant came to India illegally and collected highly sophisticated arms and ammunition meant for mass destruction. The High Court further held that he chose to select Red Fort for an assault along with his other associates, Red Fort being a place of national importance for India. The High Court has also recorded a finding that the chosen attack was on the army camp which was stationed there to protect this monument of national importance. The High Court has therefore deduced that it was an act of waging war against the government of India. It is further held that the associates with whom the appellant had entered into conspiracy had attacked the army camp, which suggests that there was a conspiracy to wage war against the government of India, particularly because in that attack sophisticated arms like AK-47 and AK-56 rifles and hand grenades were used. The High Court also took note that this aspect regarding waging war was not even argued by the learned counsel appearing for the defense. It is on this basis that the appellant was held guilty for the offences punishable under sections 120B, 121A, 121 IPC, section 120B read with section 302 IPC and sections 468, 471, 474 IPC, and also the offences under sections 186, 353, 120B IPC. He was also held guilty for the offence under section 14 of the Foreigners Act, since it was proved that the appellant, a foreigner, had entered the territory of India without obtaining the necessary permissions and clearance. Similarly, the appellant was also held guilty for the offences under the Arms Act as well as the Explosive Substances Act on account of his being found with a pistol and live cartridges. The law on the circumstantial evidence is by now settled. In Sharad vs. State of Maharashtra 1984 for SCC 116, this court drew out the following test for relying upon the circumstantial evidence. The circumstances from which the conclusion of guilt is to be drawn should be fully established. The facts so established should be consistent only with the hypothesis of the guilt of the accused, that is to say, they should not be explainable on any other hypothesis except that the accused is guilty. The circumstances should be of a conclusive nature and tendency. They should exclude every possible hypothesis except the one to be proved, and there must be a chain of evidence so complete as not to leave any reasonable ground for the conclusion consistent with the innocence of the accused and must show that in all human probability the act must have been done by the accused. The principle of this judgment is to be noted that in the last mentioned decision of Aftab Ansari vs. State of Uttarakhand 2010 to SCC 583, the observation made is to the following effect. In cases where evidence is of a circumstantial nature, the circumstances from which the conclusion of guilt is to be drawn should in the first instance be fully established. Each fact must be proved individually, and only thereafter the court should reconsider the total cumulative effect of all the proved facts, each one of which reinforces the conclusion of the guilt. If the combined effect of all the facts taken together is conclusive in establishing the guilt of the accused, the conviction would be justified, even though it may be that one or more of these facts by itself themselves is are not decisive. Stop.